Welcome everyone, and thank you so much for joining us today for Frier Levitt's webinar entitled BOPs and PBMs in Focus, Navigating Industry Changes for 2004 heading into 2025. And so we put this webinar together with my colleagues, Day and Nicole, who are here with me today as well, just to kind of put a finer point on some of the big issues that we're seeing throughout the country at the BOP level, the PBM level, and also at the federal level in Medicare through CMS. And we've found that as we transition from one year into a new year, that a lot of times these issues are definitely at the forefront of people's minds, and in some cases can cause some anxiety and concern for people. So our goal here today is to provide a lot of information about that. As we get started, a couple of things. I know that we deal in acronyms a lot, and I realize that probably most people on this webinar are very conversant with these terms, but I just want to make sure that it's abundantly clear that when we say BOP, that means Board of Pharmacy, PBM means Pharmacy Benefit Manager, and CMS, which we talk about a lot, is the Center for Medicare and Medicaid Services. Just to start briefly with a little bit of background, as I mentioned, my name is Lucas Morgan, and I'm a partner at Frier Levitt, and I work in the Healthcare and Life Sciences Litigation Group or team here at Frier Levitt. And I, along with my colleagues on my team, represent healthcare professionals throughout the country and in different various settings, especially in the healthcare and pharmacy space, working on legal matters, especially some complex legal matters involving pharmacies and healthcare providers. And I would really say that we've proven ourselves to be advocates for these healthcare providers. I work frequently with pharmacy benefit managers or PBMs, and also very frequently with Board of Pharmacy or BOP issues. And I'm at a point now in my career where I've worked in some way, shape, or form in pretty much every state throughout the entire country in Board of Pharmacy matters and handled matters with pretty much every major PBM in the country. So that's really where the focus of my work is, working in multiple jurisdictions, whether it be at the state level, the federal level, in federal court, as well as in private arbitration. Now, as I referenced earlier, I'm very happy to be joined by my colleagues, Day Lee and Nicole DeWitt, as we dive into some of these different matters and developments and considerations in more detail. And we are going to be exploring these different areas of focus. So, Day, if you can introduce yourself as well.
Thanks, Lucas. Good afternoon, everyone. My name is Day Lee. I'm one of the partners and pharmacist attorney at Frier Levitt. I handle a variety of matters for pharmacies as well as the employer/plan sponsors. For pharmacies, I handle PBM audits, FWA investigation, enrollment denial, and network termination. And, I collaborate a lot with my colleagues within the firm, including Lucas and Nicole, depending on the issues at hand. And, our firm has been very successful in terms of assisting the providers, obtaining the favorable outcomes. And we have clients throughout the country, from Hawaii to New York, from, up north down to Florida and Texas. Nicole, I'll hand it over to you.
Hi, everybody. My name's Nicole DeWitt. I'm an associate in the Healthcare Regulatory Department. I handle a variety of matters on behalf of our clients, both in the life sciences and healthcare sectors. I'm a prior litigator, so I bring that wealth of experience with me as I analyze some of the real day-to-day business issues that our clients encounter and the real continuity of business operations and care concerns that our clients have in connection with some of the topics that we're talking to you about today. I'm very excited to get to know all of you and to explain a little bit about my background in the Medicare field.
Thanks so much, Day, and thanks so much, Nicole. As we get started here, just a few housekeeping items. This is being recorded, and for all of those that are attending and registered for this, we will send you a link to be able to watch this at a later date. So if there's any information here that you want to refer back to, you will certainly have the opportunity to do that. I will say that we are not going to be taking live questions necessarily, but you should feel free to submit any questions or inquiries you have throughout the process of the webinar. And what we always do is anything that we can't address during the webinar, we will aim to follow up with you. And I always say, please feel free to reach out to us after the webinar as well. Our contact information is readily available, and we love hearing back from the people that listen in on our webinars. One of the things I do just want to mention as we get started here is just a reminder, we are trying to speak in very broad general terms here. So it's really important that this information be taken as informative and not be considered formal legal advice. Certainly, we are in a position to be able to give more formal legal advice, but we would strongly encourage that for that type of consultation that you reach out more formally and retain the firm. So again, our goal here is to be informative, and please don't rely on this in making any serious decisions without properly consulting with legal counsel, because some of the issues and matters that we are going to be discussing are very serious and may have serious implications. So with that, just a few summary learning objectives. We want to talk today about reminders about common PBM audit issues. And I think our goal here is really just to kind of preview anything that we've seen really have a lot of momentum as we close 2024 and head into 2025, raise any new areas of focus that we've seen, but also reminders about some of the things that we've seen historically be an area of focus by PBMs in the way they go about auditing pharmacies. We want to talk about, in that same vein, trending issues, both with PBMs and boards of pharmacy, but also in the Medicare space as well. Want to talk about some of the legal tools available to pharmacies and independent providers at the federal and state level. Want to talk importantly about the interplay among these various entities. And again, that's PBMs, private corporations, boards of pharmacies, which are public government agencies, as well as CMS, which is a federal-based administrative government agency. The relationships among these three entities for a pharmacy provider are really important in understanding how they work together and how they can impact your practice. When you should consider taking further action, whether it be with a PBM, board of pharmacy, or CMS. And finally, if you are going to take further action, and that looks a little different, whether it's a PBM, a board of pharmacy, or CMS, what are the options available to you and how is that done? What are the legal tools available when you make that decision to take further action? With that, I'm going to hand it off today to talk a little bit about some of the relevant contracts for consideration. I'll let him get started on some of the PBM discussion.
Thanks, Lucas. So, I assume that every pharmacy has at least one or all of the PBM that you see, PBM contracts that you see on the screen right now. CVS Caremark, Express Script, Optum Rx, as well as Prime Therapeutics. Maybe you have Humana, MedImpact, and the other smaller ones, including Navitus. So whenever you get credentialed into their network, pharmacies have to sign the provider agreement, but the pharmacy also receive or have access to provider manuals. Provider agreement and provider manuals go hand in hand, and they provide terms and conditions and even standards set forth by each of these PBMs. It may seem very long, and it maybe seem like a heavy lift to go through each of those provider manual, but I think the best practice to really skim through and then focus on certain areas, and then areas of or the sections of each provider manual, because it will provide you with the guideline on how to conduct how to go about the responding to the audit, how to dispute the audit, what needs to be done in terms of following their standards set forth by each of these PBMs. And I'll go over a little bit more detail about the implication of not disputing the audits or failure to fully dispute the audits down the towards the end of my section during today's webinar. But it's critical for every single pharmacy to be familiar with the provider agreement, provider manual, and also A lot of times, some, pharmacies who may have been operating for many years, maybe they lost a copy of the contract, right? So I think right now is the best time to ask for it because many pharmacies may not have any ongoing audits. Even though even if you are undergoing audits or termination disputes, I think it's best practice to obtain a copy of the contract. Next slide.
And Dave, just to put a finer point on that, when you say maintain a copy of the contract, is that the provider manual and the pharmacy provider agreement?
Both. The pharmacy should have a copy of the provider agreement as well as the provider manual, and look out for any updates issued by these PBMs on the provider manual. Caremark, Express Square, Optum, they regularly send out the network pharmacy education or updates to the provider manual and agreement. So please be on the lookout for those. All right, so even though PBM's provider agreement and provider manual may seem like they dictate the terms and conditions and the relationship that they may have with the participating providers or participating pharmacies, PBMs must comply with the applicable federal laws as well as the state laws. And right now, the playing field is shifting. I guess it seems like towards to the pharmacy's favor. Many states are enacting laws or introducing bills to regulate PBMs. Like for example, there's a state on the East Coast where the state requires PBMs to actually have a negotiation with participating providers before entering into a provider agreement. That hasn't happened before, right? So usually PBMs just unilaterally push out these provider agreements without without the pharmacy having a chance to negotiate the terms and conditions. Now in that state, the state requires PBMs to engage in a good faith-based negotiation before pushing out the provider agreement to their network pharmacies or any pharmacy who want to join their network. Next slide. Okay, I want to spend some time talking about the common PBM audit discrepancies. I'm sure you've heard me speaking on these topics, copay collection, drug invoice shortage, or prescriber denial or patient denial. I cannot emphasize enough about these discrepancies because they appear, on every single audit findings that I see that I handled, throughout this year. And I don't think PBMs are going to slow down. They're going to continue to use these discrepancies against the pharmacies. And I do know that each PBM, they have a team of, auditors or network managers. You know, they meet on a regular basis to come up with different ways to per se manage their network, right? Through different audits, through different audit tactics. But at the same time, as you know, they're using these as a source of their revenue because the PBMs can recoup money through audits from the pharmacies, and also may turn that audit findings into other additional sanctions such as payment suspension or a network termination, all that sort. Now, going into the copay collection, they usually require the receipt, right, showing that the amount of copay and whether the copay was paid and how it was paid, whether it be credit cards or cash. And then if it's credit card, they ask you for last four digits of the credit card. And if it's check, front and back copy of the check. And Caremark has been asking a lot about bank statement for cash deposit. I mean, it's unrealistic, obviously, because if you receive $5 copay, you're not going to run to ATM or a bank and then deposit that. I know a lot of folks use cash for, it's like a petty cash, you use for other expenses. So there's way to push back on copay discrepancy for cash receipts. I mean, cash payments on copays. And one of the ways patient attestation, right? But patient attestation, you have to make sure that there is a clear chain of communication between the pharmacy and the patient. Meaning, if you picked up a patient attestation from in person, then you have to make sure that it has the wet signature. I mean, we would prefer a wet signature, right? And then you could also consider having the patient sending a courtesy copy directly to the auditor, so that it shows that the attestation is not only coming from the pharmacy to the PBM's auditor, but also from the patient, him or herself, to the auditor. Okay. If it's fax, there's got to be a fax header, right? If it's email, it would be a good idea to make a copy of that email and then submit it to the auditor. So I think it's very important that we push on the patient attestation, for both credit card receipts or as well as the cash receipts. And the other thing that Caremark has been asking, and then Optum has asked, like, not regularly, but in the past they did, the merchant report, credit card merchant report. Sometimes it might be difficult to get the merchant report, but you have to exhaust your effort. You have to show that you've requested this, and then, whether you are able to obtain it or not, you have to show that you've exhausted the efforts to obtain merchant reports and then submit it to the PBM's auditor. So, what happens when you cannot collect the full amount of copay at the point of sale? If you look at the major PBMs provider manual, there's a section about copay, and they require you to collect copay full amount at the point of sale. Okay. Now, if you cannot collect, I mean, there are many times there will be instances where patients cannot afford to pay the full amount of copay at the point of sale, or they just don't have any method of payments at the time, especially seniors, right? So you have to show, in order to combat PBM's audits and discrepancy, you have to show that the pharmacy did in fact exhaust its efforts in trying to collect the copays from the patient. Okay, you cannot, voluntarily waive copay. There are certain exceptions where you could either enroll patients into the uh, payment plan or financial hardship, right? Or you could put on an AR account. There are certain instances where you could do that, limited instances. But one thing that you cannot do is just voluntarily waive without really vetting the patient's financial status and financial needs. Okay, so in order to do that, you need to have a standard operating procedure on copay. You need to have a high financial hardship policy. You need to have a payment plan that is acceptable by the patient, and you have to document all these. And of course, we've helped pharmacies many times on these copay SOPs and financial hardship policies. And I'm proud to say that personally, I think it's the gold standard in the industry. And then we work with the each of the pharmacies to mold the SOPs to fit each pharmacy's business model. Next page. Third-party copay collection has been a hot button item, and there are several companies out there who collect copays on behalf of the pharmacy. Okay, let's call it vendors. And these vendors, in my opinion, they're helpful, right? They facilitate the transaction, they facilitate, and then they take off certain burden off of the pharmacy's operation. However, PBMs, they don't like it. And the major PBMs provider manual, I think it was Caremark. Caremark has in their provider manual that prohibits any delegation of copay collection to a third party. So you really have to be mindful of that. And certain times, and in a limited instances that I've seen, these vendors submit test claims in order to figure out the copay and whether the claims are reimbursable by the PBMs. test claims are not per se kosher. You need to stay away from that. You should not give your NCPDP or credentials to a third party in order for them to check the eligibility or even coverage or figure out the copay. And if you like to do that, there has to be a set contract setting the boundaries and making sure that the conduct or the services that the pharmacy is receiving is in line with the current laws and regulations. Next
And
page.
one thing I would just add to what Day is saying about working with third parties is if you are considering working with a third party, and there are many of them out there that are very, very credible and reputable, but it's a big decision that you're making in the operation of your pharmacy. So we strongly recommend that you vet even that decision with qualified legal counsel, because you need to look at two things. One is, does it comply with the law? And assuming that it does it also comply with the contractual requirements of the relevant payers and the PBMs? And they're two different things. It may be legal 100%, but it may not strictly comply with the contract. And you want to make sure you're always doing both. So that's a big decision, and it is worthwhile to seek a legal opinion on that.
Exactly. All right. The other one is the drug invoice shortage. I mean, is drug invoice shortage, but this comes up every single time, right? So PBMs require the wholesaler to submit the purchase report directly to the PBMs and their auditors, right? And then they're going to try to limit the review period during the audit period, arbitrary audit period given by the PBM. Okay, and more recently, what I've seen is, and this is very expensive drug instances where pharmacy submits a claim and then submit an order for that product and then receives it the next day and then dispense it. PBMs try to not give credit on that purchases. So we have to really push against those discrepancies as much as possible. Next slide. Okay, so again, there is a 30-day look-back period that PBMs are going to accept, meaning that any purchases made within 30 days of the start date of the audit period are generally acceptable. However, many times pharmacies try to utilize their buying power, if any, and then try to make bulk purchases in advance and then stock them up. And our view is that regardless of when the pharmacy purchased, right? As long as the pharmacy can show that it has stock or it had the drugs in their inventory and then dispense throughout the audit period here, and then as long as there's the purchases equal or surplus the claims billed, it should be accepted. Okay. And the other thing is Caremark has a bulk purchase requirement. You have to give notice before you make any bulk purchases if you're going to use those for Caremark claims. And the other one is you have to make sure that, because NDCs, they change, right? And you have, especially for generic drugs, you have to make sure that the claims that you bill, claims that you dispense, have the exact same NDC. Otherwise, they're going to say a wrong NDC, and the wrong NDCs turn into a drug invoice shortage. Next slide. Okay. And more recently, pharmacies have started purchasing through platforms from other pharmacies or from other wholesalers, and those purchases, they're valid, right? They're valid purchases, and is assuming that the NDCs match, and the caveat is when you buy through those platforms, it should be individual needs, right? For those purchases were made for patient-specific needs. It's not being utilized as the primary wholesaler. Those. However, PBMs, including Caremark, have been trying to maintain the position that these purchases are not legit because the pharmacy could not provide, the T3 from the sellers selling pharmacy selling the drugs, right? And so it's not required under the law. However, it's in the provider manual. So that's what they're trying to use. Okay. So the pharmacy, let's say a pharmacy A buys products from pharmacy B through that platform. The PBM is going to say that, hey, pharmacy A, you need to provide the pedigrees from the pharmacy B, and the pedigrees would show all levels of transaction, whether it be, from the manufacturer to the wholesaler to the pharmacy B and then to pharmacy A. Okay. That T3 or the pedigrees are being emphasized by these PBMs, and I want you to really be aware of the potential shortfall on these drug invoice shortages. And of course, we this is a pretty recent trend, and then we've been handling many of these matters, and we've cultivated a way to, make sound and reasonable argument. Next slide. So what are the other PBM tactics? I mean, as you know, Caremark attaches many times 20% audit fee. If it goes over, I believe, $10,000 of the total discrepant amount. Keep in mind, there are certain states that does not allow such practice. And also, regardless of the state law, there are, if 20% of 10,000 is different from 20% of $1 million, right? So there are ways to handle the PBM's egregious ask, and we oftentimes ask them to give us a line item, like what made you um, be entitled to 20% of the audit fee. Like, why are we supposed to pay the audit fee to your auditor when the audit was only conducted at a desktop level? It doesn't make any sense why Caremark is asking for 20% and why they think they're entitled to the 20%. Okay. And then the other one is the ESI. ESI conducts, desktop audit, on-site audit, but they always do it under the disguise of fraud, waste, and abuse. Okay, because fraud, waste, and abuse, the pharmacies are on a tighter time clock, right? Usually, if you receive an audit, you get 30 days. After to respond, FWA investigation, you either get anywhere between 7 to 14 days, and then there's also the notion of state fair audit laws do not apply to FWA investigation. That blanket the sky is what ESI is trying to take advantage of. All right, next slide, please. Why should further action be taken? Because they're going to recoup money. They're going to recoup money, and they may also try to terminate your pharmacy from their network. They could also cross-terminate other pharmacies that you may have affiliation, ownership, or relationship with. And that's why you have to act beyond, act on every single audit and make sure you dispute to the fullest extent. Next slide. Impact on relationship with other PBMs. If you get terminated, depending on what PBM it is, you have the contract, the PBM it is, you may have a reporting obligation. And I don't have a hard proof, but I do have soft proof that PBMs do communicate with each other. And then I've seen pharmacies get terminated for not reporting a PBM termination, another PBM termination. So, you have to be cognizant and be familiar with the provider manual, provider agreement, any state laws out there that you could take advantage of in order to fight their egregious conduct. Next slide. This slide shows the legal tools that are available to you. Fair audit law, prompt pay, unwilling provider law, unfair trade practices. We know these laws, and federal level as well as a state level. in and out. We've used them many times. So, and also, as I indicated before, there are a lot of pressure on PBMs right now. More states are coming up with different laws to regulate PBMs conduct. And I'll turn it over to Lucas, who's gonna talk more about the any willing provider law.
Thanks so much, Day. And just to segue off that, one of the things I want to point out from Day's discussion is that notion of taking all the audits seriously and also challenging them to a legitimate endpoint. And what I really mean by that is that applies to the fullest extent possible, even for seemingly small audits. And what I would describe as small is something that may have a seemingly small dollar figure involved or a small number of claims or both. Oftentimes, and we've seen a historic pattern of this, some pharmacies will take the position of, you know what, if I don't push back on this and I just allow them to recoup the money, then everything's going to be fine, right? And the answer is that it could be, but the thing you want to really avoid down the road is any allegation that there's been a pattern or a practice, so that if a year later or 2 years later there's another audit and so on and so forth, even if the prior audits were seemingly small dollar amounts, it doesn't become part of a perceived pattern. And that's why I think you should look at how you go about handling these audits as not necessarily just a strict dollars and cents measure of return on investment. So, for example, you may say, well, it's a $5,000 audit. I don't want to spend $10,000 in time and money to challenge that audit. I would say that the value of challenging that is worth far more than $5,000 or $10,000, because it's really about preserving your contractual relationship with the PBMs, which are essential to your existence as a pharmacy. So you really want to put a lot of time into taking all efforts to work through those audits in a very methodical way. Now, shifting into a more detailed discussion about available legal tools. First thing we talk about is the federal any willing provider law, or what we might call Medicare's any willing provider law. And this is really a North Star for independent pharmacy providers. Now, Medicare, as you may know or understand, or may be apparent from the name, these laws really apply to the extent that you're doing Medicare business. So what I would say is that if you have a high percentage of Medicare volume or business, then you're going to benefit from a lot of protection from this law. But I would also say that this is really a guideline or a guidepost in other circumstances. And a couple of things I would point out about this law is that it requires the participation of willing independent pharmacy providers in the PBM networks, meaning if you are able and willing to meet the terms and conditions of participation in the network, the PBM has to let you in. Now, there's more to it than just that, though, and we've highlighted some of the language here, and that's that a standard contract with reasonable and relevant terms and conditions of participation, whereby any willing pharmacy may access the standard contract and participate as a network pharmacy. And the thing I would point out is the underscored part, that notion of reasonable and relevant terms. So these can't just be any terms. And we know if left unchecked that many of these terms would be unfair or unreasonable, especially to smaller independent pharmacy providers. So it's really important that you understand the protections you're afforded under Medicare's any willing provider law. In addition, many states also have what I would describe as complementary state-based any willing provider laws. And so what this does is this comes in to fill in the gap to the extent that you're not doing exclusively Medicare, which I would say most providers are not doing exclusively Medicare. Now, I know depending on the type of pharmacy work that you do, or perhaps your geographic location, that you may do a very high percentage of Medicare business, but many of you are also going to be doing business in the Medicaid space, which is traditionally governed by state law, as well as in the private commercial space. And that's where a state any willing provider law steps in. So what I would say is that if you're in a position where you're doing Medicare business and also based in a state that has an any willing provider law, then you have what I call a dual layer of protection from arbitrary or without cause terminations by PBMs. So just a few examples: Connecticut, New Jersey, Pennsylvania, Texas. These are a few states among many that have state-based any willing provider laws. Now, Many states have these, but not all states have them. And so to the extent that you have any involvement in legislative advocacy or anything like that, something you should advocate and push for in your state, if you know that you're in a state that does not have an anyone provider law, is for the adoption of that. And to be clear, I know that is a huge step. It takes a lot of work, but it is time well spent, because as Day has suggested, and we'll talk about this a little later, there's been a lot of positive developments at the legislative level. And so here, we spotlighted Connecticut as an example of a state with an any willing provider law or any willing pharmacy law. And here, just some of the language from there. It's not all of it, but it says no third-party prescription program shall prohibit a pharmacy from enrolling in a program except for a cause, including but not limited to previous fraudulent use of program identification cards. This is really critical. I would actually say this is one of the better any willing provider laws in the country, and it's because it's so clear about what you can and can't do. It really makes clear that if a pharmacy hasn't done anything wrong, you need to let them in the network, and they need to be remaining in the network. So we would really say that what this translates to is you may only be terminated for a cause, or alternatively, if you're seeking admission, you can only be denied admission for a meaningful for-cause basis. Now, as we talk about some of the interplay among PBMs, boards of pharmacy, and CMS, that's what we really want to emphasize when we talk about why it's so important to really focus on these audits and preserving that contractual relationship, but also your relationship with boards of pharmacy. That's because these entities have really a working relationship. And I'm gonna run off a couple of examples. PBM terminates a pharmacy from a network. Board of Pharmacy gets wind of that. The Board of Pharmacy may investigate that further. Board of Pharmacy takes disciplinary action against a pharmacy. That needs to be reported to PBMs typically. One, if you report it, the PBM may want to know more. I'm going to tell you right now, when in doubt, you need to report this stuff. At the end of the day, you need to comply with those contracts, because strict compliance is always going to serve you better than non-compliance and taking a risk. In addition, if you don't report it to the PBM and they get wind of it, they may seek to terminate you for a cause for failure to report disciplinary action by a board of pharmacy. In addition, CMS takes some sort of an action. Nicole's going to talk about revocations. That too is likely to need to be reported to both your board of pharmacy as well as PBMs. Now, I know all of this stuff can sound very scary. If I go ahead and tell these people about these different things, aren't I just going to get into more trouble? Isn't there going to be a domino effect? The answer to that question is there might be, but you are going to be in a far better position to handle that and control that narrative by getting out in front of it and being proactive and being compliant with all Board of Pharmacy rules and regulations regarding reporting obligations, as well as PBM contractual reporting obligations. That is where we absolutely step in and come into play. We work in these types of situations all the time. And I can't tell you how much of an impact proactive, smart disclosure of these things goes such a long way in preserving that contractual relationship and also maintaining a good rapport in relationship with your boards of pharmacy and CMS as well. So what are some of the common actions we see by boards of pharmacy that might lead to some sort of action that could become reportable? Failure to notify or report. I've already really talked about that, even just in passing here. Failure to operate. We often see, especially for new pharmacies or if a pharmacy has just been acquired as part of a sale. There are many states that essentially have a clock that starts ticking once that license is obtained or granted. And the expectation is that within a certain period of time, the pharmacy is going to be open and operational in a meaningful way. And if you are not able to achieve that open and operational status within that stated time period, you could be subjected to discipline. If you've listened in on any of the other webinars we've done, you'll hear that I often mention Texas, and it's just because they have very clear, easy to understand rules on this particular piece, which is in Texas, once a license is obtained, you have 6 months to begin operations. Now, in some ways, you might say 6 months, that's very doable. But oftentimes what can be overlooked is how long it can take to get into network with the major PBMs and to actually be in a position where you can start processing meaningful claims activity, such that if a Texas Board of Pharmacy inspector comes along and asks for your claims activity or claims detail for the last 6 months, it might actually reflect very little, if any, business. So that is a common action. Another one is failure to supervise or some form of inadequate supervision. So you always want to be cognizant. But again, make sure you're aware of these. The duty to report or notify your board of pharmacy of a lot of different information, but it could be something as simple as a change in hours. It could be a change of location, a change of your supervising pharmacist or pharmacist in charge. These things need to be communicated to the board of pharmacy. And when you do this, you are preventing the board of pharmacy from taking some form of disciplinary action that could later become reportable. Again, an essential theme here, and this really overlaps, it's about communication. Here it says communicate with your BOPs. I also would say communicate with CMS, communicate with the PBMs. When in doubt, make sure you have an open line of communication. It is so critical because at the end of the day, even when it's bad news that you may be communicating, I have found that if you are communicating in an open, honest, and transparent manner, in a timely manner with your boards of pharmacy and PBMs, you are going to be in a far better position than if you don't communicate this stuff. And far too often, I've seen pharmacies make the mistake of the calculated risk, which is, I'm just not going to tell them and hope that they don't find out. Now, obviously, there are times where it's an inadvertent mistake because sometimes the timeline for disclosure is very short, but I would say that ideally you have a timely disclosure. A late disclosure is better than no disclosure, but at the end of the day, it's all about communication. So I'm going to hand it off to Nicole to speak in a little more detail about Medicare and Medicare revocations.
Thanks, Lucas. I really, really want to emphasize the importance of communication and building off of the Board of Pharmacy communications. It's also important to notify Medicare of seemingly small changes to some of the operations of the pharmacy that have a very big impact on the ability of the pharmacy to maintain its enrollment. When we talk about Medicare in the pharmacy context, oftentimes taking a step back from Medicare Part D, we have these ancillary enrollments, Form 855B for Part B enrollment and Form 855S for durable medical equipment. And those enrollments can have collateral effects on the ability of the pharmacy to maintain its enrollment in Medicare Part D and Medicare Advantage plans, depending on the severity of the noncompliance. So we're going to talk a little bit more about that today. When we talk about Medicare revocations, we're also talking about the ability of the pharmacy to maintain its continuity with Medicaid as well, because oftentimes there's dual enrollment requirements such that a Medicare revocation for a seemingly small portion of the pharmacy's business may have an effect on the pharmacy's ability to maintain enrollment in Medicaid for the state Medicaid program. So we're going to talk about that a little bit more in the coming slides. What I've noted recently is that we have a situation where in the CMS final rule passed in January of this past year, we have had an increase in the ability of Medicare to revoke pharmacies and other suppliers, as well as providers, for inadvertent errors that in the commercial context, those suppliers and providers would take the position is a administrative de minimis type of breach that would warrant the protection of the Any Willing Provider Law whether on a federal level or on a state level. And as you'll see in the slide here, common errors leading to revocation in the CMS final rule, we've had a addition to the existing ability to revoke the pharmacy and other suppliers based on non-compliance with specific supplier requirements. Those are those DME supplier standards that are required under Form 855S. Also, a seemingly small issue that could give rise to a Medicare revocation is referral of an existing debt to the Department of the Treasury by CMS. That's a new change this past year. We are still waiting to see how often it's implemented, but it's an available option for CMS. And when you consider a CMS revocation for one PTAN, CMS also has the discretion to revoke the PTANs for affiliated suppliers just based on what the conduct is at issue, as well as placing the supplier or provider on the CMS preclusion list. And the CMS preclusion list means that the individual or entity is not eligible to receive Medicare Part D payments or Medicare Advantage payments for those networks managed by PBMs. So it is very, very critical for pharmacies to keep an eye out for what could happen to them and to really be ultra vigilant when it comes to Medicare reporting of changes, responding to Medicare notices in a timely fashion. Failure to preserve your rights and to timely respond could lead to a re-enrollment bar ranging from 1 to 10 years. If you're a second-time offender, you could also have a 20-year re-enrollment bar issued to your pharmacy. This essentially changes the entire structure of your business. In some instances, we'll see retroactive revocation dates, meaning for all claims which were filled after the retroactive revocation date, CMS will claw back the payment. And we'll see that come up in the context of felonies, also failure to maintain accreditation for DME supplier standards, as well as licensure, those types of issues. So really, really critical that pharmacies keep an eye out on maintaining their Medicare enrollment. And if we go to the next slide, we can talk about some of those tools to prevent issues and then how to timely respond in the event that you find yourself in such a situation. So number one, if you get a letter in the mail asking for information from your Medicare contractor, respond right away. Oftentimes, even if a contractor is very, very backlogged, just making sure that you have that response logged in timely is critical to maintaining enrollment. In addition, you want to keep, and this is a non-exhaustive list, there's so much here, and really, you know, this is just the tip of the iceberg, but I want to make you all aware that maintaining those internal calendar deadlines for updating any changes to your insurance policy, making sure that it's renewed, renewing your surety bond, timely reporting changes of ownership or changes of managing control. In addition to any changes in the products that you sell on the DME side for the purposes of accreditation. Sometimes that triggers a change in your accreditation requirements. So you need to keep that in mind. Whenever you get a revocation notice, you know, the first step is always looking at your PBM manuals, looking to see if you have a immediate notification requirement. In addition, you want to make sure you have those proofs available to you in order to submit to the contractor within 35 days of receiving the revocation notice or the date of the revocation notice. to demonstrate compliance in a corrective action plan. And in order to preserve appeal rights on the initial appeal, you want to submit that reconsideration request within 65 days of the notice. That first line response is where you have the best opportunity to create a robust administrative record, and in order to preserve all your rights in subsequent appeals, and also to put your best foot forward to the hearing officer so that they can apply discretion in your favor. Because unfortunately, if you get to that second level appeal before an administrative law judge, the standard is not in your favor, and the standard is review for a clear error of law and not a de novo review of the facts and how the judge would decide the case if he or she were hearing it for the first time. Next slide, please. So here we have collateral effects of Medicare revocation, and I was saying a little earlier, we have this issue where if you have a Medicare termination on a Medicare enrollment under Form 855B or S, you could also have an immediate termination of your state Medicaid contract. And what dictates that is whether or not your termination is considered for cause, to the point that your PTAN and your NPI number are included on the DEX database notifying state agencies to terminate the pharmacy. Interestingly, because we're having more communication between state Medicaid agencies and Medicare, state Medicaid terminations could also trigger a Medicare termination, and that's a basis to revoke the pharmacy as well. So getting ahead of any narrative and explaining what exactly happened when you are faced with a termination really is critical to demonstrate that you are a compliant provider and you have taken appropriate corrective actions to maintain compliance, because compliance with applicable requirements is critical, and you really want to be in a position where you're mitigating damages to your pharmacy, and really, take the issues head on and quickly. And with that, I'd like to turn over to the next slide and continue the conversation with Lucas.
Thank you so much, Nicole. So just kind of segueing into what are some of your legal rights and remedies, and how do you go about deciding whether to take a next step, whether it be to challenge a Medicare revocation, whether it be to challenge some sort of conduct by a PBM, or to engage in a contested matter with a board of pharmacy. And we'll talk through that. One thing I do want to address is a question that came up during the course of the presentation about any willing provider laws. And the question is essentially, doesn't the PBM have to be located in the state for the any willing provider law to apply? And the answer to that question is no, they do not. You have the protection of an any willing provider law that exists in the state in which you are located, and the PBM is obligated to comply with that. The other thing I would say is, from a practical standpoint, PBMs are nationwide. Their reach is nationwide. So they are doing business in essentially every single state in the entire country in some way, shape, or form. So they really are obligated to comply with the law, both at the federal and state level, and that includes applicable any willing provider laws. The other thing I would say is there are instances where you may have the protection of more than one state any willing provider law that may come up in a situation. And this is just an example, but let's say you're a New York-based pharmacy, but you also happen to do a lot of work in the North Jersey area. We see that, or in the South Jersey area if you're based in Pennsylvania. You could argue for application of both. And now that may be a legal argument that needs to be made by an attorney. But the main thing is the PBMs must comply with these laws. And that's regardless of the actual state that they are located or headquartered in. Now, as far as the legal rights and remedies available, obviously we talked about any willing provider laws. For PBMs, one of the key things is if I get to a level where I have a dispute, maybe it's a recoupment, maybe it's a termination that's being challenged. For PBMs, if you want to know, check the contracts. Each and every one of those contracts. In most cases, it's the provider manual. In some cases, it's the provider agreement, but they will have very detailed dispute resolution provisions. You will find that typically there is one of two venues, either private arbitration, or you would be in a court venue, and that could be federal or state court. It varies depending on the PBM and some other factors as well. For disputes with CMS and boards of pharmacy, these are administrative proceedings. So these are going to work through what we might call a quasi-litigation setting. So you're going to have some of the characteristics of a court proceeding or an arbitration proceeding, but what you'll often find is that because it's an administrative agency, it is more streamlined. But again, each and every one of these different entities has a corresponding process for resolving disputes. With arbitration, we see the major arbitration associations, the American Arbitration Association, JAMS is another one. Also, American Health Law Association. I would say a smaller percentage of cases are handled by the American Health Law Association, but we see a high number of matters that are handled by the American Arbitration Association and JAMS as well. As far as courts, those are federal or state. You know, if I were going to just give one example, and this is very well known, because the cases are public, for disputes with Express Scripts, to the extent that they rise to the level of litigation, you would be in the federal district court for the Eastern District of Missouri. There are instances where a case may not be able to be filed in the federal court system. In that case, it would default to the state court system. Now, with all of these situations, I do want to be clear, there are exceptions. There may be instances where, you know, the expectation is arbitration, but there may be a carve out for some other venue like court, and vice versa. You may normally be in court, but there may be a reason why it belongs in arbitration. So it's important to have an understanding of which venue you would be in. As far as some of the differences, I would say in arbitration, you typically are going to have a more streamlined process, limited discovery. Depending on the circumstances, that can be a benefit. I would say it's going to move a little quicker, more expedited, and it is a proceeding that I would say is presumed to be confidential. Most arbitrations are confidential in nature. As far as court, I would say some of these things are the opposite of arbitration. So where arbitration is presumed confidential, court is presumptively public. Now, there are some exceptions. As far as the pace at which court proceedings move, I'm not going to say that court is slow, but you've often heard people say that the wheels of justice move or turn slowly. Court just moves slower than arbitration. There's no two ways about it. That's why you see a lot of people have a preference for arbitration, especially depending upon the type of dispute involved. But keep in mind, the reason the wheels of justice turn slowly and move slowly, there's a lot of reasons for that. One of which is to encourage resolution and private resolution among the parties by way of a settlement. So there's going to be unique benefits to both venues. The other thing is in court, you're going to be working in front of a judge as opposed to a private arbitrator. Private arbitrators are typically privately compensated. Some people are concerned about that increasing substantially the cost of a litigation or a lawsuit. But what I will say is typically those costs are offset by a savings on the limited discovery or other aspects of how the proceeding is handled. Some factors to consider, again, we've talked about it, but you want to know where you would be litigating or arbitrating. I will say a lot of proceedings are now handled virtually, and only the most essential proceedings are usually handled in person. You also want to know if there's fee shifting available under the contract. And that's something to consider on both sides of the equation. If you have a very strong case, obviously fee shifting would be beneficial to you in many ways. By contrast, if it's a case that you're seriously considering, but you feel like it's pretty weak, you want to factor in the potential implication of not being successful in your matter. As far as how you go about deciding whether to pursue arbitration or litigation, certainly there is a cost component there, but I think it really goes to what is at stake. If it's your participation in the network, it may be very hard to put a value on that. It may be priceless. It may be essential to your operation and existence. So that's a big factor, is what's at stake. And then, of course, and this is obvious to many, but what's your likelihood of success? And that's certainly something that we can help you assess. As far as with boards of pharmacy and CMS, again, it goes to what's at stake. I would suggest that you always want to engage, especially with the Medicare space, as Nicole said. If your privileges are subject to revocation, you definitely want to make sure you're doing everything to preserve those privileges. With boards of pharmacy, you want to engage with them early on and see what all you can do. I would say when dealing with an administrative agency, you want to be cautious. It's very important. And when I say be cautious, you need to engage, but you should be aware of how the process works. And that's where you want to seriously involve qualified legal counsel. And then the last thing, and this actually applies to everything, you do want to be cooperative, but I also don't want you to misunderstand what I mean by cooperative in this setting. I'm a litigator. That is what I do. So many people think that means that I'm adversarial by nature, but there's a place for that in certain litigation settings. But at the end of the day, I'm all about getting my clients the best results possible under the circumstances. And one of the smart things is to be cooperative where appropriate. There are a lot of reasons for optimism as we wrap up here. As Day alluded to early on, we've seen a lot of activity throughout the country at the federal and state level. Here's just a few examples. And so as we work to wrap this up, because I see we're just about a minute over, I'm going to hand it off to Day to make some concluding remarks.
Thanks, Lucas, and thank you all for joining us today. We talked about a lot of topics. So please, look out for an email. We'll provide a link where you could download the recorded version of this webinar. And then if you have any questions, just feel free to reach out to any one of us. We will be happy to hop on a call or engage in a discussion via email. Thank you.
Thank you all.